DNA Court is now in session, Your Honorable Kate Wilson presiding. I am grateful for the opportunity to talk to Ellen Matloff about her role as an individual plaintiff in the 2013 U.S. Supreme Court BRCA gene patent case. In this case, SCOTUS ruled that naturally occurring DNA sequences cannot be patented and overturned the Myriad Genetics patent on the BRCA1 and BRCA2 genes. These genes are associated with hereditary breast and ovarian cancer. Ellen is the CEO of Counsel and serves as the Forbes contributor on genetic counseling, genetic testing, and digital health. We talk about standing up for patients, persevering despite resistance, and the importance of this landmark decision on genetic research and innovation. Let's get started. So welcome to the show, Ellen.
Oh, thank you, Kate. I'm glad to be here.
Before I ask the first question, I thought it would be helpful to give some context to our audience about what a patent is, since that's part of what we're going to be talking about. The definition that we had talked about was a patent is a legal right granted by a government to protect an invention for a limited time. And it gives the inventor exclusive rights to their invention, including the ability to, 1, stop others from making, using, or selling that invention, or 2, license others to make, use, or sell the invention. So that's about patents in general, but what is a gene patent?
You really hit the nail on the head, Kate, because a patent implies that you have invented or created something. And so when you say you have a gene patent, that implies that you have invented that gene. And herein lies the problem with the gene patent on BRCA1 and 2, right? Because those genes are genes that each of us has, both men and women. We all have 2 copies of every gene that are on the numbered chromosomes, including BRCA1 and 2. We were born with it. No one invented that gene and put them into our bodies, but when this patent was approved by the U.S. Patent Office, they were essentially saying that a single company had ownership of this patent for something that they had invented. And that's where the problems began.
Okay. And so that was part of my question, is that it's genetic material. It's something that's unique to each person and inside of our bodies. So I find it interesting that somebody was even able to be awarded a patent for creation of the genetic material.
I find that interesting too. And I will say, let's take the silver lining from this story. And the silver lining is that if you are a person with an interest in genetics and also an interest in law, there are very few people at your intersection. And I found this when this case went to the Supreme Court, that not only did the U.S. Patent Office not understand genetics well enough that they granted this patent for something that Myriad Genetics did not create, BRCA1 and BRCA2, but even at the level of the Supreme Court, the justices of the Supreme Court really grappled with understanding these concepts. And that leaves an opportunity. It's an opportunity for attorneys, paralegals, people interested in the law, but who are also interested in genetics, or genetic counselors who already know genetics and may want to get a paralegal or a law degree as well, to really have ownership of a space where very few people understand both areas.
Yes, I am trying not to jump out of my seat because, having worked for some large corporations that deal in genetics, that was always an area that was really challenging to find somebody that kind of fit the middle of that Venn diagram. So I wholeheartedly agree that that is an opportunity for people who have an interest in both legal and science, especially in the genetics realm, to pursue or look into. So the patent itself, I believe, the case was or the decision was made 2013. The patent had been owned by Myriad for some time before that. So it wasn't
Oh, yes.
necessarily a relatively new thing.
It was not. It was not a new thing, but they began enforcing the patent several years after they had it in around 1997, 1998.
And I think part of that was due to the factors of some of the testing was cost of testing was dropping, and there were maybe some more labs or opportunities for people to try to start offering that BRCA testing. So maybe they were seeing more people popping up that they were, again, kind of enforcing to not have that competition.
At the time, it was really academic laboratories. And
Okay.
I know this because at the time I was a relatively new cancer genetic counselor at Yale School of Medicine, and we had a DNA lab. And when I say like an academic DNA lab, we're talking about antiquated machinery and people doing a lot of manual labor and charging $1,600 for full sequencing of BRCA1 and 2. And so I don't think we were really seen as much of a threat by Myriad Genetics. And our lab director was offering BRCA1 and 2 testing, as was the University of Pennsylvania. You might remember at the time they were one of the labs offering it to outsiders. And then suddenly we all got a cease and desist letter by FedEx saying, you must all shut down, not only in the United States, but international labs as well. But there wasn't a big commercial competitor. They shut down all of the academic labs first.
I see. Okay. So that's sort of the landscape at the time where this really started being enforced. And one of the things to think about is with gene patenting, like we said, it's interesting to try to patent something that's genetic material that everyone has. How did it impact the genetic testing landscape? Like you said, the academic labs were being shut down. Overall, what were some of the other things that happened because one lab owned the patent?
Oh, a million things happened. So overnight, we had been charging $1,600 per person for this testing. Overnight, that charge shot up to $2,400 per person. And we were forced to change our entire workflow and to send our samples to Myriad Genetics, which we were getting our results back a little bit later. But importantly, some of the research projects that we were involved with at Yale, like there was a large research project offering every patient with ductal carcinoma in situ of the breast BRCA1 and 2 testing, and it was a fully funded study through the NIH. And so suddenly the cost of that testing changed. And so the budgeted cost of $1,600 went up to $2,400. And that researcher had to go back to the NIH and say, there's been a change. Can you fund us for the rest of it? She was a very well-known, established researcher, and they gave her the money. But it suddenly became much more expensive to do research on BRCA1 and 2. And insurance companies were also taking notice, like, oh, this is now going to cost more. Are we going to pay for this? So it changed a lot of things very quickly. And I should say that $2,400 is where they came into the market. And even though the cost of testing was being driven down by better technology, the cost of this BRCA1 and 2 testing kept going up, up, up over time.
And also this was, 15 plus years ago, so 2400 then is probably different looking now with inflation, I'm imagining as well.
Correct.
So you mentioned that it was making it challenging for research, and then with some of the academic labs that could no longer offer it, harder potentially for people to get the testing done, or to be able to do it. When did you get involved in the BRCA patent issue? Because you said you were kind of a cancer genetic counselor, had access to an academic lab that was then no longer able to offer this testing anymore. Was that when you got involved, or did it take a few other things?
So, in terms of involved, I immediately said, this is the wrong thing to do and we should fight back. And the lab director, who had been involved in a lawsuit before, said, I'm not getting involved. I will never be involved in a lawsuit again. So he was out. And I put together a slide deck on this, kind of telling the story of like, this is what's happened. This is why I don't think we should be able to patent human genes. And interestingly enough, that brought a lot of ire from people who said, what are you talking about? We patent everything. Why would anyone do research in this if there were no patents? And there were only a few cases that had precedent before this. So a lot of people were not on my side, let's say that. And I put together a grand rounds. I went around giving it at local hospitals. I started speaking out about this. I started speaking out about it on our national listserv. And at the time, Myriad Genetics was the largest employer of genetic counselors in the United States. So I got a private message from the NSGC after several months saying that if I kept speaking about this issue on the NSGC listserv, I would be invited to leave because I was insulting so many of our colleagues. So that's how it started. It took many years before, and I actually have a cousin who is a patent attorney. So I spoke to him about it. He introduced me to several colleagues of his who were well-known patent attorneys and who would take on pro bono cases. And each of those patent attorneys would go back to their firm and look at their conflict of interests. And they had a conflict of interest either with Myriad Genetics or with one of their many investors. And so none of them would take the case. So I really had very little to zero hope that this would ever become a case, but I kept squawking about it and I started writing about it. And I got rejections from some of the finest journals in the country who told me that this was insane. And then a friend of mine was watching 60 Minutes and she saw that a well-known bioethicist named Art Kaplan also mentioned gene patents. And so I tracked down his email address and emailed him and said I'd been trying to get this manuscript published and would he consider being a co-author, which to my amazement, he did become a co-author and made some edits to the paper. And then with his name on it, it got published in a well-known bioethics journal. And from that, I became kind of known as someone who was fighting this case internationally.
So by publishing that, helped gain more traction, more awareness, more people reaching out to that probably felt as you did as well, like this is something we need to figure out.
They did, and still I thought, like, who has several $1,000,000 and a fine law firm who will get involved in this? I didn't have either of those things, but someone made a donation to the ACLU and they decided to take on this case. And they contacted me to ask if I would be involved in the case.
I see. So they were, I guess, with the ACLU, they were looking at different cases to take on. But at that point, had you officially filed a case or it was with the ACLU's taking it on? That was when it officially became a filed case.
I had not filed a case. I did not have the money. I didn't have the law firm. The ACLU filed a case and brought some of their finest attorneys to the table and some of their finest experts, and then brought in a few of us who were individual plaintiffs, and then several large organizations like AMP who became plaintiffs as groups.
And that's the Association of Molecular Pathology, and they basically govern a lot of the lab testing that happens in the United States.
They do, and they also are willing to get involved, which there are a lot of organizations that you think would have gotten involved with this. You know, clinician organizations, patient organizations, and I will tell you that most of them would not. Also, some of the big time people who were involved in genetic counseling and testing, either as oncologists or molecular geneticists or genetic counselors, all said no.
So that was one of the questions I was going to ask is how did people at your institution and the genetics community as a whole feel about your involvement in this case?
Well, when I was invited to be a plaintiff in this case, I'd been already fighting the case in my mind and with my lectures and with my papers for so long that I enthusiastically said yes without realizing what it meant to say yes to be involved in a case like this. And so the ACLU, a few of them got in a car, drove from New York to New Haven. I met with them. I thought they were brilliant. I thought their approach was brilliant. I said yes. And then one of my colleagues was like, you might want to check with general counsel about that and make sure that as a Yale faculty member, you can be involved in this case. And I had one of those moments like, what are you talking about? I have no idea what you're talking about. And realized that, oh, yes, I have to meet with general counsel, and went over, met with a whole table of experts at Yale that I didn't even know existed. They were very polite. They listened to the whole thing. And then one of them said, we really admire that you are getting involved in this case to help patients and to help research. But we think that your involvement in this case, which was originally, Kate, I don't know if you remember this, it was not only against Myriad Genetics, but against the US Patent Office as well.
I did not remember that.
Yeah, at the beginning. So they said, we think your involvement as a plaintiff in this case may preclude you from continuing as the director of cancer genetic counseling here at Yale. And I kind of took a moment and said, you mean you're firing me? I was like shocked.
Yeah.
And they said, well, it's involving the US Patent Office. We have many dealings with the US Patent Office all over Yale, both the medical school, the undergraduate, other graduate programs, and this would not be something that Yale wants to be a part of. And I said to them, listen, I cannot lose my job. I was the founder of this program, I'm the director of this program, but I also have to be part of this case. Like, help me. And they were kind enough to get me an attorney pro bono who took my case and worked out a deal with Yale that Ellen Matloff from Branford, Connecticut could be a plaintiff, but Ellen Matloff from Yale School of Medicine would not say a word. And that's how we handled it.
Gotcha. Yeah, it's challenging in some of these things where you are fighting, especially as being a patient advocate, and I think especially with genetic counselors, like there are things we want to get done on behalf of our patients that we might get into something and all of a sudden be like, oh my gosh, I had no idea that there was this much larger ecosystem now that I have to also balance out, like with my workplace.
Yes, correct.
I appreciate though that they maybe found a way to kind of navigate that.
It was more than they needed to do, and I am forever, forever grateful for that.
When you were talking to some of these legal groups and to the ACLU, what did you tell them about how the gene patents were impacting patients? So how would you describe how patients at the time were being affected by these gene patents?
I gave them a lot of examples, but one of the examples that was the most salient to the case was that we realized, and Mary Claire King published data showing that a significant proportion of patients who had a mutation in BRCA1 or 2 had a mutation that was not being picked up by Myriad sequencing. It could only be picked up in deletion duplication testing, and Myriad at the time was not offering that service. And so I had a whole list of patients whose personal and family history was striking enough that when they tested negative for BRCA1 and 2, like an affected family member tested negative, what I really knew is that we had missed something, not that they were BRCA1 and 2 negative, that it was either a deletion and a duplication in this gene or in another gene which we had not yet discovered, which, as you recall, we didn't have these gene panels that we have now. And so I contacted Myriad Genetics and said, Mary Claire King has published this paper about deletions and duplications, you are not offering del-dup testing. So in the patients I have who test negative, but who are still what we would consider uninformative, may we run deletion duplication testing? And they said no. So even though they weren't offering it, they said we have a patent on the whole gene, both of them, and you may not do something extra. And so I was able to find a patient, not one of my patients, she's from Buffalo, New York, who had a family member who had BRCA 1 and 2 testing in a striking family history and tested BRCA 1 and 2 negative, and then the sister, this woman from Buffalo, developed ovarian cancer. And we were able to use her as an example that if someone else, because she carried a deletion, if someone else had been allowed to do testing on those genes, then that original consultant could have been found to test positive. Her sister would have been found to test positive as well, and would have had the options of removing her ovaries prophylactically. She did not have that option, and now she has a life-threatening disease. And so that was the argument of all of my arguments, and I had many, that really held the most weight.
Yeah. Yeah. I mean, it demonstrates how something that could have been proactive, preventative, wasn't able to happen because the patient didn't have the appropriate test, because it wasn't even available.
It didn't have access, right?
Yep. Didn't have
Correct.
access to the testing. You talked a little bit about gene patents and research, and that researchers sometimes were motivated by the availability of patents, or that they could do some research and then potentially get a patent, make some money right off the research or what they create. What are other ways that gene patents will impact research and testing, and does it help or hinder innovation?
So we can actually look at real data on this to say, before the patent, let's look at how much research was available on BRCA 1 and 2, how much research was done, how much was funded, and how many papers were published. And then let's look at what happened after the patent case. Was there less research? Was there less data published? And the answer is no, there was more. And so I think the argument that the lack of the ability to patent a gene hinders research, I think that argument is now dead and buried.
I think, and I think it was one that was kind of surprising to hear about, that, if I remember correctly, during the time with the case, that was one of the things that was being said in court, of like, to say, oh, it's okay to have a gene patent, right? Like, it helps foster this innovation. So it's good to note that we do have this case to see the pre and post impact of real actual data of how a gene patent impacts the research and innovation.
It's very important, and let's not forget that it wouldn't have ended with genes. If you're able to patent things that already exist in nature, and you're able to go over and be like, I'm putting a patent on this. For example, let's use the example of an eye, a human eye. Let's say that someone patented an eye. And so if you developed a cataract and you wanted cataract surgery, your local eye surgeon could no longer do the surgery. That you had to go to a specialized surgeon who maybe was part of a chain of eye surgeons that had access to that patent. And so instead of that surgery costing, and I'll make up a number, $10,000, it now costs $100,000. And maybe your insurance says, we're not going to pay for that. You're going to have to pay for that out of pocket. And so only people who have enough money to pay out of pocket can save their eyesight. You can kind of see where this is going, right? In terms of, oh, I'm going to take something that already exists in nature, and it doesn't have to be a human thing. It could be a tree, a type of tree, a type of grass, all sorts of things that already exist in nature, and you can patent them. And then if
Mm-hmm.
people want access to those things, they have to go through you or pay you money. It
Mm-hmm.
just, that's not the definition of a patent. That's not how patents were intended. And I'm very grateful that the Supreme Court made the decision they did.
Mm-hmm. So let's talk a little bit about that decision. What was the ultimate determination? I mean, I think we've dropped enough spoilers, but what overall was the decision in 2013?
So in 2013, I actually had the very good fortune of going to the Supreme Court while this case was being heard. And I am not an attorney, and I did not know what happens at the Supreme Court. But what happens, even if you're a plaintiff in the case, you're not like sitting up front and you're not talking to the Supreme Court. The attorneys talk to the Supreme Court. I sat in the nosebleeds, 20 rows back, which was thrilling. But I got to hear the arguments and hear what both attorneys were saying. And I will say, we went into the case as the underdog. I don't really think many people thought we had a shot in hell
Mm-hmm.
at winning this case. And then when I heard Myriad's attorney make his case and use an example that was, if you're walking through the woods and a branch falls off a tree into a stream, and as that branch moves in the stream, the water is starting to shape the branch, and it shapes it into the shape of what we now know as a baseball bat. And so 2 miles down the stream, someone picks that piece of wood up and thinks, here's how I'm going to use it. They should be able to patent that branch because it's a baseball bat, and they can patent it into a baseball bat. It was in that moment of hearing that argument that I thought, oh my God, we might win.
Hmm.
That was a terrible argument, in my opinion, and a terrible comparison to BRCA 1 and 2. And that was the first moment when I thought, I think we could win.
Mm-hmm.
And so it was weeks later that the decision came out. And we were told that most Supreme Court decisions at the time, I think, like they gave us a very specific thing, like they come out on Thursdays in June, or like a.
Mm-hmm.
And so it wasn't a Thursday; it was a different day. And my daughter actually was graduating from preschool that day. So I'd left my phone in the car and gone into her graduation. And when we were leaving, it was like a downpour of rain. So I had to carry her out, get her into her car seat, go around, get into the car. So by this point, I'm soaked to the bone. And I noticed that my old fashioned like flip phone, right? Because this was a long time ago, was blowing up. And when I opened it, I couldn't believe it because it said something like, you have 15 voicemails. And I had all these texts. And the very first text was from my friend Debbie, and it said, you won.
Wow.
And that's how I found out. And I started bawling. And my daughter, who was little, I think she
Mm-hmm.
was 3, was like, Mommy, what's wrong? What's wrong? And I explained to her, like, these are happy tears. A really good thing happened today. And
Mm-hmm.
the thing that happened is that there was a unanimous Supreme Court decision outlawing human patents on DNA, and the nuances around that statement I'm not getting precisely right, and my
Mm-hmm.
husband, who is an attorney, would be horrified. But that was what I took away from it. And interestingly, the person who wrote that decision was Clarence Thomas. So
Mm-hmm.
that was a fairly divided Supreme Court, not as divided as it is today, but it was
Yeah.
really exciting to be part of it.
Amazing to take something from a having the thought, this isn't right, this is hurting our patients, to then have it go all the way to the highest court in the land and to get that decision. That I mean
A
that's
long
that's
time.
yeah, a long time, but a very impactful one. And I thought it was interesting that you talked about the argument that the Myriad attorney made. And I do want to dive a little deeper into that because as somebody who's worked on the lab side, sometimes I get pulled into conversations about nuances, right? Where it comes into okay, we can't patent the DNA itself, but we can potentially patent, right, the technology that allows us to interrogate this gene. But again, the DNA, the organic material itself cannot be patented. And so I think, tell me why you felt like that argument was sort of the opening to, oh, maybe this will go in our favor.
Because Myriad didn't develop a new technology. We were already doing sequencing of this gene. Sequencing was an old technology that had been used for a long time for many genes. They hadn't done anything new.
Mm-hmm.
And so, I think it's really telling that Myriad now has a new CEO, Paul Diaz, who made a statement that the Supreme Court was right. And so even that company who lost a lot of money in that decision, looking back on its history, can say, you know what? You shouldn't be able to patent a human gene. And you're right, Kate, if you develop a precision medicine or a new technology or you use it in a different way, should that be patented? Of course, because you've invented something.
Mm-hmm.
That's different. That's what a patent is for, an invention. But you can't just yank out a gene or an eyeball or a branch or whatever and say, we're going to patent this. Sorry, it doesn't
Right.
work that way.
Right, exactly. And I think that's a good distinction because that's ultimately what the case was, and not necessarily talking about a new technology, right, that was being utilized to learn this type of information. It was the sequence itself. One of the things, too, I'm thinking about is okay, so post 2013, that comes out. It's, I, for one, as a practicing cancer genetic counselor at the time, was pumped because, like you said, I wasn't sure if that was going to happen. And so it was very exciting. And I will say, it felt like very quickly there were a lot more options for testing for my patients.
5 hours. That's how long it took from the decision. 5 hours.
Yeah, I would say I remember, I think we had some order forms in a few days, probably of multiple places in our clinic after that. So post 2013, what types of protections are there now in terms of gene patenting? I mean, you can't necessarily patent the gene sequence, but are there other things in place at this point to um, either prohibit people from doing the same thing, namely, I think the Supreme Court decision, but are there other things that help guide like the use of genetic material or how to monitor patent use?
So I think what you're asking is really a legal question.
Okay.
And so I'm going to be smart enough to say that I am not the one who should answer that question. But there is another case involving gene patents that has bubbled up over
Mm,
the last year or two that a lot of people are watching carefully. I personally don't have the legal background to speak about that eloquently and accurately, so I'm going to leave that to someone else.
understood. And I will say that's probably a plug for me because I've been looking for somebody with that legal and genetic expertise. So I'm continuing to dig because I certainly would love to chat with somebody who is an attorney and has that background.
I have some suggestions for you that
Okay,
I
we'll
give you.
talk offline. I'll get some of those. Is there anything that we haven't covered that you think is important for people to understand about this case or about ownership of genetic material in general?
I don't have anything to say about ownership of genetic material. What I would say is for those of you who are thinking, wow, it's really insightful that like a 25-year-old genetic counselor could say, I'm going to get involved in this case in 1997, and by 2013, it will be in front of the Supreme Court, and maybe we can win. And you think that that was a really smart path. That wasn't the path. The path was at all. The path was, I'm seeing something. I think this is wrong. A lot of people are telling me to shut up, but I'm going to write about it. I'm going to speak about it, and I'm going to try and raise awareness about it.
Mm-hmm.
And then it kind of went from there, but it wasn't that people were supporting me and holding me up as like, wow, you are a hero in the community and we're going to promote you at Yale and all these patient groups think you're awesome and your professional group thinks you're awesome. They didn't until the Supreme Court case. I was considered a troublemaker
Mm-hmm.
and kind of a fight monger.
Mm-hmm.
So if there's something that you see and you feel pretty strongly that it's wrong, or you just feel pretty strongly about something, I would encourage you, write about it, give lectures about it, gather people around it, and don't give up. It takes a long, long time.
Mm-hmm. I would say, what kind of advice or insight do you have to not give up? Because it does seem like there were roadblocks, things being thrown up, and a lack of support. So, how did you keep going?
Yeah, I mean, I kept going because I didn't see another path. And I watched from 1997 until the 2000s when the ACLU came forward. I kept seeing all of these kind of negative things that were happening as a result of the patent and kept adding them to my list. And when I couldn't discuss it on the NSGC listserv anymore, I started a blog and
Mm-hmm.
discussed it on a blog. And I just hung in there because it was screwing over my patients. And I knew that someone had to say something.
Mm-hmm.
And I decided it was going to be me. And then when the ACLU came along with money and with a plan and with a legal team, it became a whole different ballgame.
Right. Right. So, it was a matter of there really is no alternative. I have to talk about this. I have
Right.
to get it out there. There really isn't a choice. And then doing that long enough that then the right opportunity, the right partner comes along.
And that was lucky. I imagine most of the time you don't have someone who comes along with several, millions of dollars in a legal team. We got lucky. And I think that the part I played in this is that I talked about it, I reported about it, even if it was on a blog and in
Mm-hmm.
interviews and in academic papers. Like, I wasn't on the nightly news every night, but I reported about it and documented it and kept telling the story and kept telling the patient stories. And that's what I contributed. And I also wouldn't back down, even when it might have been smarter for me to back down.
Right. Right. Had already read a lot of the news articles and the things that came out, but it's just very impressive to hear your story, firsthand account of going from having this thought to then to the culmination that it did, and then the impacts that case has had since then. And so I just really appreciate you being here, sharing it. I am going to put a few different resources too in the show notes of some of the papers that you had mentioned. And if I can find that recent case too that you mentioned with Gene Patton, if there's an article on that, I'll add that in too. So if people want to read some more about that, they can. But again, Ellen, I just really appreciate you taking the time and being here with us today.
My pleasure. Thanks so much for having me, Kate.
For more information about this episode, visit allaccessdna.podbean.com, where you can also stream all episodes of the show. Check out our Patreon at patreon.com/allaccessdna and consider donating to get bonus content, submit questions for our guests, and connect with other genetic curious individuals. Any inquiries on the podcast can be sent to allaccessdna@gmail.com. Please rate and review the podcast on Apple, Spotify, YouTube, or wherever you listen. This helps other people like you discover the show. Note that this podcast is for entertainment and education and is not intended to be a substitute for professional medical advice. Please consult your physician with any questions you may have regarding your health. All Access DNA is an independent podcast hosted and produced by me, Kate Wilson. Designed by NKJ, created the logo. Thanks for listening and join us next time.